Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a family law firm out in the Worcester area, and she is an amazing attorney. She has an incredible staff, and she's here to talk to us today about something very interesting and something that we've never covered before. What is the judge thinking? and this is a whole process. So I want to thank you so much for joining us, Nicole. I can't wait to talk about this topic.
Thanks for having me, and it'll be interesting because I don't have that crystal ball, but I think I have some insight.
Well, of course. I mean, how many cases would you say that you have worked on in your career? Because it's been 20 years at least.
Oh, well over, at least probably 20,000.
Oh my gosh. So you must have a few insights on the judge and what not to do. And I have to say, I am one of your clients, and I'm always really interested in what your take is when it comes to this, because I just don't question it. I'll just do whatever you say, and I can see that the things you tell me to do actually really work, and I can see the judge getting pissed off at certain other things. Even just watching other people's cases while you're sitting in court, it is really interesting to see people stick their foot in their mouths.
Not only that, but you also have the people that I just sit there again. I watch the gallery for hours on end waiting for my case to be called. So I know that insight. I can see that about people that put their foot in their mouth. I can see what happens in my cases. And every once in a while, I'll call up the attorney and go, hey, remember this case that you did? What was the outcome? Just because I'm interested about it, because it does kind of go, ooh, that was bad. So we definitely know some tidbits and we know some information.
Well, let's talk about first just what you're supposed to be like, how you're supposed to act, how you're supposed to dress, that is really going to be more pleasing to the judge. I know I see it in your face that you've seen a lot of people do it wrong. So let's talk about how to do it right.
Let's do it right is the best thing to say. It is being professional. You don't have to wear your Sunday's best. Always wear your Sunday's best at trial. I want to have a suit jacket if you're a man. I want to have a button down shirt. I want to have a tie. I want to have at least non sneakers. Even if it's loafers, it's better than sneakers. From a woman's perspective, again, dress suit, dress pants, um, even if it's just a pair of slacks, but you make sure that you're presentable. You don't come in with those sneakers, you don't come in with the ripped jeans, you don't come in with something that falls down to your butt. um, Look like you're being respectful, because that is a person that's going to make that decision. And if they don't think that you're respecting them by standing in their courtroom, then that's already one mark against you and you haven't even opened your mouth. Take off your ball caps. It's one of those things that people forget often when they have them on. The court officer will always go, and you go, oh yeah, I forgot it was there. And your sunglasses, take off the sunglasses. We don't need to see them on your head. That's not an appropriate spot for them. So just those simple things of just acting like an adult and being professional.
I know that looks like a relaxed summer look. You're just gonna go around some kind of a beach town somewhere and hang out with your Jeep with the top off. And that is not the proper look for court, and it's not going to impress anybody, less the judge. So that is really good advice. As far as and I know you and I actually witnessed one of my favorite moments that I have mentioned many times, because when I talk about the law um, with attorneys on these interviews, and just how you address the judge and your language and with your body language. um, honestly, best thing I ever did was hire you and have you talk for me, so that while I'm going through something emotional and upsetting and possibly like a huge, serious, life-changing event, you're able to step back and just do your job and look at the strategies, and you know the rules. So when you have someone in there representing themselves, it sometimes can be comical and sad.
Yeah, unfortunately, I think you hit the nail on the head. It's one of those things that you'll have people that will have notes and they're like, oh yeah, let me just see, right here, and they'll do the bullet points, and that's fine. The problem is, um, if you're reading it, you're like this, and it's not something that the judge can really get into. So you really have to kind of use it as a bullet point. Oh, this and blah, 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 blah happened. Now, okay, now I can talk. Like you want to have it as literally like you're doing a presentation. Obviously, if you have an attorney, use your attorney. That's what they're there for. I think the other thing is, stand up straight. Don't, yeah, great. You lean against the desk. Yeah, okay, judge. I mean, if you want to write notes down, that's fine too. But you really want to look like you're respecting that person, that you have your act together, have papers on different piles if you need them, so you can kind of correlate them with one another as you need them. Those are the kind of the key points. Don't show up and expect that you're going to use slang and win your case. Now, there are times when you have to use it because maybe you're quoting somebody. They called me a effing bitch. Okay, well, that's the proper way to say it versus the other alternative. So there's things that you can do. And, if you say that, you go, but they use the real word, Your Honor. Of course, the judge knows that too. But if you feel like you need to say it, you can say it something like that. Or they said the B word. There's ways that you can get around it without really being slanderous and vulgar, and the judge doesn't want to hear that. That's not going to win any points. It might get your point across, but it's certainly not going to give you any points because they're going to go, what do you think, this is Jerry Springer? And it's not. The judges take their job seriously and they want to understand your case. But again, if you're treating it as something that is on a TV show, then you're not going to get the respect that you need from the judge.
That is an interesting point, because a lot of people, it's their first time in court and all they've ever seen was what was on TV. I mean, actually, the first time I ever got pulled over, I don't know if I ever told you this, I was 20 and I was going over the speed limit on my way back from the Cape. I don't think it was by much, but I got pulled over by a state cop and I asked him, what seems to be the problem? And he said, don't you ever ask a state police officer what his problem is. I was like, whoa, okay. So, I mean, you can say the wrong thing if you don't know what you're doing. And if you haven't been to court a lot, and if you're not a lawyer who has been in the courtroom. So what kind of things do you see and what do you suggest?
I think, again, it's planning. Know what you're going to say in advance, know what the other party is going to say, and have a comeback. But make sure that comeback is at an appropriate time. You don't get to talk over the other party. You don't get to say they're lying. You don't get to do all of that stuff. Let the judge know that you have one other thing you need to say when it's your turn, and say it. But you've got to have that structure. Again, you don't walk into your boss's office, or hopefully you don't walk into your boss's office and say, hey, you're a jerk. Well, guess what? Where do you think that's going to get you? It's the kind of the same thing. So when you're talking over another party, or more importantly, you're talking over a judge, then that's going to be a problem. So have all of your information, have documentation. If you want to show documentation, have it available. Make sure the other party's seen it already. Make sure they have a copy of it. Make sure you have all of your ducks in a row before you go in. And, more importantly, ideally, make sure you have your attorney standing next to you.
Yeah, I mean, and that makes a lot of sense. Being organized is so important because there's not a lot of time that they allow you in court. And if you're, like you mentioned earlier, trying to look through your notes and you look unprepared, it's not going to bode well for your case. So let's talk about, how things come into the judge. when there are exhibits, when there are pieces of information and different things that you're going to show the judge during this, a trial or whatever the case is that you're there for. How does it work, and how do they process all of that before they talk to you?
Well, just know that first and foremost, if it's not a trial, you're probably not going to be able to show the judge anything. Maybe you can get certain things in. Sometimes the judges go, do you have that, counsel? I'd like to see that. Because it's a police report, for example, or it's a, DCF statement or something from the school. And there's conflicting stories about how many days a child missed, things of that nature. Obviously, I can look at that and see exactly what it says as a judge. But a lot of times it's just going to be you articulating what you want. So you can say, hey, in the police report, it says blah, blah, blah. Guess what? Opposing party, if they're on their ball, is going to object to that, and you're not going to get that in. So you want to be able to summarize the documentation adequately. There are certain times that you can attach them to appropriate motions or pretrial memorandums. Sometimes you can't. Sometimes the other attorney is going to move to strike them. So definitely know when you can bring things in and how you can bring them in, but it's not that simple. At a trial, you better make sure you have the originals. You want to make sure you have originals of all the stuff. Don't tell me it's a copy of something. Give me a photocopy of a picture. Great. Where's the original picture? You're going to show me a police report, but it's not a certified copy. You're going to show me somebody's quarry record or school records, and they're not certified. They're not going to come in. If the opposing party is doing their job proficiently, then it's not going to come in. So it's something that you really want to make sure you have all of your copies ready, that you have them in the right order, you've exchanged them properly, and more importantly, you've gotten the proper certifications. Because all too often I go, Judge, I have this document here I want to show you. And the judge is going, just say what you have to say. But Judge, I have this document. Sir, can you please just tell me what you want to tell me? And so they're getting frustrated because they're like, but I have this document. And then they'll go, okay, I'm sorry, reading. And then again, opposing counsel is going to object to you. So it gets very flustering as a pro se litigant because you don't know how to get your point across. And that's the biggest thing, is when we're doing this, you need to be able to show exactly what you want to say and how you need to get that across. And sometimes, and most of the times, it's without using those documentation. Obviously, at a trial, you want to make sure you're concise. The judge does not want to see 50 pages of bank statements. They want to see the one page that you're referring to that is October 5th of 2017, and it says $5,000 withdrawal. Okay, why is that important? They want to see that particular thing. They don't want to see all those other statements. So again, you need to know how to get those in. And you need to be concise in what you actually do show the judge, because the judge is not going to flip through 50 pages of bank statements to find that one smoking gun that you think it is.
And that is really good advice. One of the things that I found very interesting and very impressive about you is just, on an occasion when we wait for 2 hours for a Zoom call with a judge, the other attorney did all the speaking, and the judge and the other attorney were speaking, but you didn't say anything, and neither did your client because the judge didn't ask you anything, and it wasn't pertinent at that time for what she needed to know in order to move forward on that particular item. Can you talk a little bit about the importance of just speaking when spoken to when it comes to the judge, and how they need to nitpick little bits of information out to make their decisions?
Most judges will at least look at the pleadings before them. So they're going to say, okay, this is a motion for temporary orders. This is a pretrial. Let me read their memorandums. So they're going to read what they're supposed to look at. They're going to know what questions that they have. So they have the documentation, they have the financial statements, they have what they need. Okay, so what do I need to know about these particular family? what do I need to make a decision about this particular thing that is requested of me? A lot of times, especially pro se litigants, they'll talk about A, B, and C, and the judge is like, but all you asked for was Z. So what are you talking about? I don't care about all that other stuff. And that's where a lot of people lose, kind of their whole emotions, because they're like, well, but judge, no. The only thing before me, sir, is this particular thing. And then you have to know the standards. Is there a standard in place on that particular motion? If it is, have you been able to prove to their satisfaction that it reached that level of standard that the judge has any authority to rule on? So you really need to know what you're doing when you're going in, what you're supposed to be arguing about, not getting off on that tangents and going off in space that doesn't matter because the judge has put her pen down, looked up, and is just kind of staring at you. Like, why am I listening to you? I'm not writing any more information down because I have no more notes to take because this doesn't matter. And at some point, the judge is going to stop you, and the judge is going to try to redirect you. And if you don't get redirected, they'll go, thank you. I've heard all that I need to make a decision on this case. Counsel, anything else from your side? And they'll go to the other side, and then they'll ignore you. So you really want to make sure that you know what you're going to be presenting to the judge, how you want to present it, and whether or not your standard is met, and how you're going to prove that standard.
That is so clearly the way to make a better impression on a judge, is to just speak when spoken to, do your homework ahead of time, be organized, and make sure, most importantly, that you have an attorney who can help you through all that, just in case someone pushes a button while you're in front of the judge. And I'm sure you see that happen all the time.
Yeah, it's really one of those things that it's nice when you're in person because I can start kicking you under the desk. But judges, you didn't hear that. But that's the reality. A lot of times I'll put my hand on your hand or your hand on your shoulder going, and sometimes you'll get it and sometimes you won't. And then I'll look at you afterwards and go, what were you doing? Because a lot of times, unless the judge is specifically asking you a question, you shouldn't be talking. There are times that either your attorney doesn't know the answer because why would I ask you that question to even know that answer? Because I'm not in the judge's brain and thinking exactly like the judge, that I'm going to need you. Or more importantly, the judge is saying, hey, Erica, what about this, this, and this? Obviously, you're the only person who can answer it. I can't answer the question. She's not asking me. So again, that's who it's being directed to. So you really want to know your place. You really want to, theoretically, a lot of times clients will go, but Your Honor, can I just say one thing? And thankfully, a lot of the judges will go, why don't you defer to your counsel and see if she will let you talk? And I love when judges do that because I'll hit the mic and go, what? And then I'll make that determination. But again, for you to make that determination, there's a reason why either I haven't said it or maybe I didn't know about it. Maybe it is something that's important. But I also can convey that information to the judge that you just whispered in my ear. So it's good to consult with your attorney rather than saying, hey, judge, I need to talk to you about something.
Yeah, that makes sense. And this is a great lead into my last question. And of course, if there's anything else you need to add, then that's great. But we've talked a little bit about some of the things that really piss off a judge. Do you have like a checklist of things that you see all the time? Like you see someone come in, they don't got an attorney, they don't have an attorney, and they sit down and you just know that they're going to do these 5 things and it's not going to go well.
And I think, we hit on most of them throughout this, not dressing appropriately, not being prepared, not knowing what you actually need to talk to the judge about. Obviously, those are all big things. I think the other big part of it is going to be the people that can't focus, the people that are rolling their eyes. We love those people because we're like, really? And I've had people on trial and my client's being really nice, but his family behind me is doing that. And now you're pissing off the judge, and we know who the family members are because they're either sitting on my side or they're going to testify later on. So it's those types of things that you go, really? It's just bad bad things to do in general. I mean, it's just one of those things that you go, you know it when you see it, and it happens constantly. So again, be on your best behavior. Act like an adult. Don't bring food into the courtroom. Don't bring drinks into the courtroom. Don't bring newspapers or books into the courtroom. Have all of those things out of your sight. Don't bring your cell phone, and if you do, make sure it's off. Don't even have it where it's going to be on vibe, because oh yeah, but I forgot, my daughter used the phone before we got here and I forgot to check it. Unless you're me, who's always in vibe, chances are it's going to ring. I've had judges and court officers stop the entire proceedings and say, who is that? And then they've publicly admonished them. I had one hearing which I was at, and I was amazed that the judge said it. She listened to the whole hearing, and she said, and do you remember when we were on Zoom the last time? We were in person this time. Do you remember we were on Zoom last time? Yep. And do you remember what you said? You called me a vulgar name right before you hung up, and you thought that Zoom was over. Do you remember that, sir? Um, um, I don't know. So you want me to get the audio tape for that? Because you know it's recorded. And I'm sitting there going, oh my God. And so he got this huge public admonishment in the courtroom. And the only reason why I think the judge didn't lock him up was because the parties had reached a full agreement. And amazing enough, this gentleman was so smug that when he turned around, he's like, and I'm like, oh my God, do you not get it? And I'm just thinking, you're going to have to go back in front of this judge again. Do you not think that the judge is going to know that that's happening? So really, stop the nonsense. Again, she has the authority to lock you up. And so those are things that are really crucial that you really need to take into consideration. This is your judge for the next however many years. So treat that judge with respect, because piss them off once, guess what? Chances are they're going to remember it, and they're not going to be nice to you when you come back the second or third time.
And man, there is always a second and third time. It's never over. Well, I want to thank you so much for coming on today. This has been a very eye-opening interview, looking at things from the judge's perspective. Not a lot of people realize what they should be doing and how they should be doing it. And so we really appreciate all of your advice and your time today, Nicole.
Thanks for having me.
You are welcome. Thank you so much, everyone, for watching. And we will look forward to seeing you next time. Have a great day.